Association for several years. Ma'am is also associated with a number of research and academic organizations like Northeast India History Association, the Northeast India Political Science Association, the Indian Association of Women's Studies, etc. Ma'am has jointly worked on a research project on tribal tradition and democratic governance in Northeast India with London School of Economics and Politics, London, and was a part of the Crisis State Program of the London School of Economics and Political Science. Ma'am has also shared the online comprehensive of Northeastern Hill University and successfully resolved the issues of sexual harassment within the university. And ma'am has also produced a several number of research scholars under her guidance who are working across the country. So now I welcome Dr. Manorama ma'am to talk on the topic of human rights from the perspective of gender and law. Thank you. Ma'am. Ma'am, you can proceed with your lecture.
Thank you, Pallavi, for welcoming me and introducing me to the participants. And thank you, Dipen, for giving me this opportunity for interacting with the participants from not only Northeast, but I understand they're the participants from all over the country. I decided, as you see, that the topic which has been put before you is human rights from the perspective of gender. And gender and the law. Now, how much I can talk about the law, I don't know, because I'm not basically a lawyer, but definitely I will try and focus upon those issues of gender relations in the society, on which we feel that there can be, some kind of amendments to laws, or where we feel that the laws have not been very gender friendly. Now, I'll begin with this, that why I have used the significance of the term of using gender and not basically women. Of course, what I would have liked to talk on, or what I would have focused on, is human rights as women's rights also, or the other way around, women's rights as human rights. But just a minute. Yeah. But the point is that I use the term gender basically to bring into focus the idea that if you use the term women, then what happens is that it becomes a little narrow, in the sense that there are many other say individuals or groups who are there in the in the society who get actually left out, and therefore gender is a much more wider word. It's a much bigger encompassing word, and therefore I use the word gender in order to make it more inclusive, because gender is basically, it is used in the feminist philosophy, feminist parlance. It is used as a term which is not related to the biological sex, which most of you, I think, would know. It is basically used as to refer to certain identities, certain kinds of special special characteristics which the society constructs for what we call the male and the female. And so in the context of women, I think it has the most beautiful lines which has been said is by Simo Bora in her very famous work. The Simo Bora is many of you must have read her. She is one of the most important philosophers in the center of the whole feminist debate from France. Simo Bora's major work, Second Sex, is almost like, it's a classic. Everyone reads it. And she begins with this very interesting word and line. She says that a woman is not really born, she's made into a woman. So merely by being born as a female in biological sense, it doesn't mean that female will come out to be the woman which is given certain characteristics, certain identities, certain specificities of behavior, etc., by the society. That becomes the woman. So the woman is a gender concept, whereas the female is basically, it's a biological concept of being born either a male or a female. So that's why I thought I'll use the term gender, because gender also includes can include a lot of others who are as marginalized as women in our society. So a major debate which actually began, which has been going on since the Universal Declaration of Human Rights by the United Nations, and that debate has centered around the question of women's rights as human rights. There is no doubt that this is as it should be, because though the United Nations Declaration proclaimed all human beings are born free and equal in dignity and rights, but it took almost 45 years to confirm that that women's rights were also human rights. So initially that was not the situation. Human rights were something different from what was considered to be women's rights. But such a statement, and it took a long time it was only in 1993, almost, almost 2 decades in a way, no, a little less than that. That after the Convention on the Elimination of All Forms of Discrimination Against Women, which is called the CEDAW, entered into force, that the Human World Conference on Human Rights at Vienna in 1993 finally makes this very significant statement that women's rights are human rights as well. Although this was a welcome move towards reorganizing the fact, or rather recognizing the fact that one half of humanity also had rightful claims, and emphasizing the neglect of women's rights as a human rights, neglect of women's rights as a violation of human rights, and drawing attention to the relationship between gender relations and human rights violations. It at least drew attention to that. Yet, it also raises this question, why women's status as human beings entitled to rights should ever have been in doubt. And that question has to be raised, and it has been raised, that why, when you're talking of human rights, why weren't there was a special concern for the rights of women? But whatever it may be, such a statement in the United Nations World Conference on Human Rights a decade ago, or decade or more ago, was perhaps necessary to bring into the public arena this entire debate on the transformation of the concept of human rights from a feminist perspective. Now, before I go any further into this issue, because basically I will be focusing on women's rights, but I would also like to show that how, while talking on women's rights, whatever has been the claims and demands of the feminist movement, the women's struggle for getting equal rights, also can include those others who have been marginalized because of their sexual preferences. And that's why I have used the word gender rather than using the word women only. But a large part of what I will be talking about will be based on the rights of women and women's rights as human rights. Now, but before we go into this, it is also necessary today, in the second decade of the 21st century, to understand that if women are marginalized in the society for no other reason but for their sex, there are also other individuals who have different sexual preferences. That is, they are outside the heterosexual the restrictions or heterosexual ideas of the society. They have different sexual preferences, like the gay, lesbians, gay, bisexual, transgender, which are basically, we use the term LGBT plus community, and we have today been termed as the third gender, who experience intolerance, discrimination, harassment, and threat of violence due to their sexual orientation, in contrast to those that identify themselves as heterosexuals. So these groups, they are also equal individuals in the society, but just as women have been sidelined, marginalized because of their sex, these groups have also been sidelined and marginalized in the society because of their different sexual preferences. They don't fall into the normal heterosexual boundaries. And they face inequality and violence at every place around the world. It is not something that happens in India, but throughout the world, these groups have faced violence. And that has become more marked after the 1990s. And that's where you find the movements for their equality, they themselves organizing for their rights, basically in the last part of the last century. Now, if we consider what Eleanor Roosevelt said in 1958, which was almost a decade after that is 10 years, and she actually spoke on the 10th anniversary of the Declaration of Human Rights, that the ultimate test of human rights rests on how they play out in the world of individual persons. And this she relates to, she said, how individual human rights play in the lives of individual persons in their neighborhood, they live in, the school or college that they go to, or they attend, or the factory or farm or office where they work. So if we consider these terms, then it becomes, or consider what she said, Eleanor Roosevelt said, then it becomes clear that an individual's access to human rights cannot be circumscribed by sexual orientation, gender identity. And this sexual orientation, gender identity has been termed SOGI, sexual orientation, gender identity. And this term is becoming popular, particularly from the time that a book was published in 2020, which was written by Kerry O'Halloran. Kerry O'Halloran. The name of the book is Sexual Orientation, Gender Identity, and International Human Rights Laws. And he has actually gone into this whole question of gender identity, how gender identity is, cannot be, same as sexual orientation. And he, of course, focuses basically on those countries which have, on the lines of common laws in those countries like Britain, Ireland, and he uses, that complex. But the theoretical, discussion which he draws up is extremely useful for understanding the question of marginalities in the society, particularly marginalities which are based on sexual preferences, if they are different from the dominant heterosexual preferences or heterosexual norms in the society. So therefore, he has argued very well that in many countries, the rights enjoyed by heterosexual couples are not enjoyed by same-sex couples, and they are prohibited from those rights. As a result, these groups face discrimination and cannot enjoy social protection schemes like health care and pensions. So because there are certain laws which say that who are the people who can enjoy healthcare laws, who can enjoy pension. And if it clearly marks out that you have to be a man, a male or a female, and then all those who do not fall into that description will obviously be discriminated against, and they will not be allowed to enjoy those. and enjoyed those privilege or protection of those schemes. Whoever has it, will you please switch off your audio, please?
Dr. Midusmita Devi, ma'am, please switch off your mic. It is disturbing us. Midusmita Devi, ma'am.
Thank you.
Yeah.
The LGBT people even hide their sexual orientation and do not disclose it due to fear of losing their jobs. And I think this is one of, this can be that, a whole group of people have been forced to hide their identities for fear of losing jobs, for fear of not getting welfare, not getting into welfare schemes, etc. But fortunately in India, a lot changed for the LGBT, or what we call the third gender, on 6th September 2018, when the Supreme Court of India issued a historic verdict unanimously ruling that Section 377 of the Indian Penal Code is unconstitutional, as it infringed on the fundamental rights of autonomy, intimacy, and identity. And thus, the Supreme Court of India actually legalized homosexuality in India, because under the Indian Penal Code, the 377, Article 377 of the Indian Penal Code of 1860, which is a very, very colonial law. I'll come to that a little later. All those who were considered to be, involved in what it called unnatural, in relationships which were unnatural to nature. I don't know who actually, how that could be defined. Unnatural to nature, they were to be considered as criminals, and as criminals they could be punished, you see, with imprisonment and even something greater. So the Supreme Court, therefore, Supreme Court of India in 2018, it gave this historic judgment that 377 was read down, and it legitimized, legalized homosexuality in India. It's decriminalizes homosexuality in India. The court explicitly overturned a 2013 judgment of itself, because the first court which had actually decriminalized it was the Delhi High Court. But when there was a move against it, there was a petition against it, and it came to the Supreme Court. And in 2013, the Supreme Court actually turned down the Delhi High Court judgment. But then there was a petition against this judgment in the Supreme Court again. And then in 2018, Supreme Court actually overturned its 2013 judgment. The court, though the situation has actually changed slightly after the Supreme Court judgment in 2018. That is, at least, they will not be considered, if you are not a heterosexual, you are, you are a criminal. That at least is not there. The perceptions and mindset of large sections of the Indian society and their behavior towards transgender has not changed much. I think that's the sad part of it. Therefore, even the scrapping of Section 377 has not been sufficient in securing basic human rights to the LGBT plus community in India. Section 377 of the Indian Penal Code of 1860, which criminalized sexual intercourse against the order of nature. That was what was there in the 1860 Penal Code, against the order of nature. It was a British colonial hangover in the country. Amongst many, I'd like to tell you, as a student of history, we go into the traditions and cultures of different, communities in the world, in different countries. And I think O'Halloran has done this very well by, bringing in the question of many indigenous communities. So there are indigenous communities in Australia, amongst the Native American tribes, as also in many aspects of Indian culture, this rigid binary distinction imposed on matters of sexuality and gender was actually a result of the law and social mores of the colonizers as per the norms which were prevalent in Britain in the Middle Ages, in the maybe 15th, 16th century, and particularly what we call Victorian period, and also as per the values set by Christian principles. So certain acts were called sin, certain acts were called, they were morally not right. But amongst many of the indigenous communities in various countries, this binary division or this idea of sin, etc., was actually not there. There was a more, inclusive kind of a question of social relations. The Indian Penal Code of 1860 was therefore imposed upon a culture, on the Indian culture, which actually had traditions of accepting eunuchs, which we would call the hijras today, within social respectability. For instance, you have the legends of, the stories of Arjun in their years of, being outcast or being outside. The whole story of Brihannala, or there are many documentation or even descriptions of homosexual behaviors. For example, if you look at many temple carvings, and at various times, same-sex love has been accepted as a sexual practice. It is quite acceptable, even though it was not accepted as a different identity. In those times, perhaps this question of identity was not so important, but same-sex relationships were not, condemned or not looked down upon. And in fact, we have in the histories of very early Greece and Rome, where young boys, in their teens, etc., as they were growing up into manhood, were expected to have relations with younger boys, of the same sex, because there were certain traditions which felt that it would help in the growth of their manhood or whatever it was. So, what was criminalized by the colonial rulers in India was not actually considered a crime in many of the indigenous tribes, even in many parts of Indian culture. So it fell upon the Supreme Court in the National Legal Service Authority versus the Union of India. That was the case, the Legal Service Authorities versus the Union of India, to decide upon the question of whether there was a need to recognize the transgender community as a third gender for the purpose of public health, education, employment, reservation, and other welfare schemes. Now, it's really a landmark judgment, and if you go into the details of the judgment, I have made a few slides which I will send to Dipen immediately after this lecture, so that he can share it with you. And I have given the slides on this idea that this very, very funny practice of giving MCQs have to be, we have to do that, because I don't support it at all, because in the multiple choice questions, what can you ask? You can ask only basic names and dates and things like that. But these lectures that we are sharing with you are supposed to be, because we are at a different level of the intellectual world, and we are supposed to be discussing ideas where we may not come together. And in the areas of social ideas that we discuss, there cannot be a black and white answer. There cannot be yes and no. You can say no, but I may have 10 ways of saying that this is yes. But since it is something that has to be followed, the organizers also don't have an option. So the MCQs have to be sent to Dipen, otherwise he'll be very unhappy with me. So I will definitely do that. But in view of those MCQs, I am sharing some slides with Dipen so that he can share it with you. And so in those slides, I have given some of the details of this very landmark judgment of the Supreme Court. And where the first point was that the non-recognition of the identities of the LGBT plus communities or the third gender was actually a violation of Articles 14, 15, 16, and 21 of the Constitution of India. I think which is a very, very important thing that was said. And the Supreme Court actually also directed the government of India to treat the members of the third gender as an economically and socially backward class. And there were also directives which were seen where the transgender community was to be seen in the light of the other backward classes or OBC. And the court finally said something extremely important, and that is the one part which I'll just read out. The court also took cognizance that a conflict between one's birth, gender, and identity is not essentially a pathological condition. So rather than adopting a treatment of the abnormality, the focus should be on resolving distress over a mismatch. So here, in simple words, what this meant was that the court recognized the difference between both the gender and biological components of sex. Although the judgment defined gender attributes as one's self-image, sense of sexual, that is, an individual's deep emotional or psychological sense of sexual identity and character, which is not restricted to the binary sense of male and female, but can lie on a much broader spectrum. Now, this, I think, is an extremely radical and progressive judgment that the Supreme Court has said, that a person's sexual identity cannot be based only on the male and female heterosexual spectrum. It has to be a much broader spectrum, and all those other alternative sexual preferences must come into the throes of law. What I think is that if we extend this idea of the Supreme Court on gender, if we extend it, it could be seen in terms of gender as a social construct, because when the Supreme Court is talking of, psychological, emotional and individuals' emotional and sexual identity. Now, what constructs these identities? These identities are constructed by the society. So this is what actually takes us nearer to this whole idea of gender as a social construct, which gives a particular identity to the person, which actually should be seen as not connected with the sexual attributes of the person. So a person can have an identity of, can be born as anything, as a male, female, with those biological specificities, but the social identity of the person should be one as an individual, a citizen with all the rights and dignities that is given to a citizen, irrespective of their sexual preferences. Therefore, and that is where the rights of the LGBT plus community actually comes in for discussion, to get in almost in line with the rights of women, because women have also been fighting for their identity and their right to live as dignified individuals in the society, not as some kind of attachments of the husband, the father, the brother, but an individual on her own rights. This is what the big entire women's movement has been fighting, and that's why it was so important for the women's movement from the feminist perspective to look at human rights as such, so that it gives a person the right to live as a dignified citizen of the country. Whether to what sex they belong is immaterial. So this is something, I think, which the Supreme Court judgment of 2018 definitely tried to establish, and we can almost obviously take it further. So when talking about human rights, therefore, in the society today, we must understand that it must be seen as something for every individual in the society, irrespective of their social, sexual preferences. Now, the arguments in favor of such an approach was first raised by the feminist movement, and that's where we come to the women's rights, because many of the arguments of the women's rights movement can be actually used for the struggle of the LGBT community as well. These issues were raised by the feminist movement when the struggle for the rights of women began. Thus, when today we focus on the women's rights as human rights, we need to consider the discriminations which have been faced by the third gender or the LGBT plus community also. Now, there have been important feminist scholars who have written on human rights as women's rights. Scholars like Charlotte Bunch, Elizabeth Friedman, Julie Peters, to name only a few of them. I think if you Google them, you will get them. Charlotte Bunch, B-U-N-C-H. Elizabeth Friedman, F-R-I-E-D-M-A-N. Julie Peters, who have not only related their this debate to the question of global challenges to human rights in the 21st century, but also to the growth and evolution of the women's movements in the last decades of the 20th century. And they have tried to redefine social concepts like democracy and development. They said that the whole idea of democracy, development, these kinds of social concepts need to be redefined in terms of women's rights as human rights. As Charlotte Bunch has very correctly pointed out, that women's issues should not be ghettoized or relegated to a separate sphere that remains on the margins of the society. Because usually that is what happens. Even today it happens that if one is going to discuss something which is a women's issue or feminism, then that becomes ghettoized even within the academic arena. Then that kind of a seminar or a discussion is always attended basically by women. And it is usually they think that the speakers must also be women, which is unfortunate because it is an issue which cannot be ghettoized and put into a group because women know their problems. They have to share it with the larger society. So all women's issues, therefore, as Charlotte Bunch says, must become parts of the larger society. And these issues should be moved from the margins to the center by questioning all the crucial concepts of our social order so that these concepts can better address the concerns of women's lives. Now, there are certain fundamental concepts of our society like democracy, development, and human rights, and these therefore need to be transformed. These concepts need to be transformed so that when policies on these matters are formulated, they can incorporate and respond to the experiences of women. So when a new law has to be maybe made on some issue, whether it is a public issue or a private issue, then the experiences of women must be also central to it, and experiences of others who have been marginalized because of their sexual preferences. Now, in the context of gender relations, women's freedom, dignity, and equality are continuously compromised by the customs of the society, by the laws, and by the society in general in many ways that men's issues or experiences are not. In fact, the concept of rights itself has never been a gender-sensitive concept. The whole concept of rights, it is an extremely androcentric or a male-centered concept. If you go into the whole history of it, which I have done in some of my writings, I've shown that how the entire idea of rights is hardly includes any sensitivity towards the rights of women. So over decades now, various women's groups have been focusing on addressing women's issues like women's civil rights and political rights, organizations which are working at grassroots levels have been drawing attention to various kinds of abuses to which women are subjected, like inequality of opportunity in education, which is so glaring, employment, healthcare, rape and domestic violence, giving value to childcare and domestic labor, like that, this must be given value to. It's not just free labor that comes. Now, if one looks into the issues raised by the LGBT plus community or movement, one would see that the third gender belonging to this, belonging to this LGBT group also face almost the same abuses. If you look at the, the discrimination, violence, the, lack of opportunities that they face, the third gender faces, it is almost like what women have been facing all through and face also today, the same kind of abuses. These issues are perhaps recognized as parts of the women's rights movement or the LGBT movement, but they have been considered as marginal to international law's more serious responsibility for human rights. So when international laws are being made, then there are very serious responsibilities to human rights, whereas these kinds of abuses which women face, which the third gender faces, those have not been taken, these have not been the center of discussions. What the makers of the laws of human rights at the international level have failed to see is that the traditional human rights ideas are based on a male model and applied to women as an afterthought, if applied at all, and very rarely applied to the third gender. So if we look at the concept of rights, which has been used in this whole discussion of international laws for human rights, that concept of right is still a very male concept. And therefore, automatically, obviously, it does not include the experiences of women. It does not include the experiences of the third gender either. The concept of rights has always been perceived as dealing with agencies of the state, acting on behalf of or against a body of people largely defined by men. So human rights violations has always been seen in those terms. The state as an agency violating the rights of the people, and which people, of course, has been defined largely by men. Now, this has been so because the Western educated, propertied men who first advanced the cause of human rights, they feared the violation of their civil and political rights in the public sphere. And so this public sphere has become the important arena for human rights activists. They did not fear violation of their rights in the private sphere, because in that sphere, private or the domestic arena, because there the men were the masters. In the domestic sphere, they were the masters, and there was no way in which their rights could be violated or taken away. It is important for women to have their civil rights protected, no doubt. Obviously, in the public sphere, the civil rights of women must be protected. But much of the abuse and violation of the rights of women is part of a much larger socio-economic and cultural pattern which make women vulnerable to abuses which cannot be strictly categorized as political. If you say political civil rights, you may not be able to strictly characterize them as political. And in maybe they'll say that there are no laws against this because these are not political rights. So you cannot mainly call them political or caused by the state alone. The state may not be responsible for it. So you cannot say that if those abuses of women's rights are there and they have been violated, it cannot be called human rights because the state is not involved in that. In this situation, human rights standards may be invoked to protect. We have to, that is what the women's rights movement did, to try and invoke human rights standards to protect women, as when applied to protect women from rape, because at least in one case, those human rights laws are used, that is to protect women from rape in detention. Because if they're in detention, then the state definitely gets involved in that. But if their rights are violated in the domestic arena, then the state does not get definitely directly involved in that. So it's not considered to be a violation of human rights. And this is what the women's movement has been fighting against. They said that the same standards be invoked to protect women, or human rights organizations may take action on behalf of individual women whose, the whose rights have been violated. But the sad part is that human rights work has been traditionally viewed as being concerned with state-sanctioned or condoned oppression, the state-sanctioned oppression or state-condoned oppression. That means violation of rights that take place in the public sphere and not in the domestic sphere. Now, this sphere is far removed from the domestic or private sphere to which women have been relegated by the society for centuries. The domestic private sphere has always been considered to be the sphere of the women. It is in this private or domestic sphere that most violations of women's rights take place, whether it is in terms of reproductive freedom, which may mean life and death to a woman in a place where the maternal mortality rate is high. So if she doesn't have a control over her body, if she doesn't have control over her procreational rights, then obviously it is a complete violation of human rights. And so laws must have to be in place which will at least be sensitive to these aspects. And in a place where, in those areas in India, far off, corners where the maternal mortality rate is high, there having an extra child or having every additional child could be a life or death question for the woman. And so that sensitivity has to be understood. Or also, discriminatory family law, or just a right to be free and exercise choice, whether about employment, whether or marriage. In all that, a woman's experience or women's sensitivity towards women is very, very important. Here it is important to keep in mind that India has actually a plural legal system in place. Now, there's a very interesting book which has been edited by Indira Jaising, one of our leading lawyers of today. And the book is, it's called Men's Laws, Women's Lives. And in that, Indira Jaising also has her own paper about gender justice and the constitutional, the constitutional perspective. Now, in that, she has very clearly showed how there is, and it is known that there is a dual system of, legal or laws. One is, that which is the secular laws. That is one system. The secular laws, those laws which are secular in nature and uniformly applicable to all in the public domain, as in administration, in trade, commerce, etc. And there's a whole system of courts which are open to all. Everyone can obviously approach the courts. And that system is in place to implement these laws. The other is a codified system of religious laws that relate to matters in the private domain. That is the area of personal family matters such as marriage, divorce, guardianship, inheritance. These religious laws may be enforced by the same system of courts that administer secular laws, as in India, or by religious heads who administer personal laws, as in other countries like Bangladesh, all these countries which have a colonial past. This personal law inevitably relate to the regulation of the family. And these laws define the family and they have defined the family as a heterosexual unit. I think that's a very important point that we should remember in the context of rights of women, as also more important in the rights of the third gender. That the family has been, in the personal laws, family has been defined or has been defined as a heterosexual unit that has a legal sanction that gives legal sanction to cohabit, live together through the recognition of heterosexual marriages and legitimize procreation. These also determine the rights of individuals within the family as wives, as mothers, as sisters, as brothers, and as widows. Now, these laws also regulate inheritance. These personal laws also regulate whether a woman can inherit property or whether she cannot or what she can do. Now, against this background, we need to understand today, in the face of the new realities that is there before us in the society and the new lived experiences of women and the third genders, that the entire legal definition of family or marriage should be re-looked into. I think this is important, that you cannot today at least define the family only in terms of family need not be a static unit, and it has never been a static unit. We had the history of big, joint families at one time. Today we have the very nuclear families of, father, mother, children. So the idea of the family definitely has changed, but this idea, this heterosexual idea of the family also needs to understand change and undergo change. And also we need to understand that the family or the concept of marriage also needs to undergo a change, because marriage need not only be for procreation matters. Marriage could be also an alliance of companionship, an alliance of necessity sometimes. But this whole idea that it is necessary and it is needed only for procreation, to legalize procreation, I think those ideas, even in the legal frameworks, these need to be debated and need to be redefined in a very, very basic manner. Now, the colonial rulers, they had a personal view. I mean, they had their own views about personal laws, because they wanted, didn't want to alienate the indigenous population, the local population in India. So they thought that the British always thought that they will not interfere with the religious practices and traditions of the people. So they let the personal laws remain as such. And in course of time, the rulers, from their perspective of Christian patriarchy, they legitimized the system of personal laws. And that's what we have as a set of personal laws today. So today, marriage is therefore seen as the necessity for procreation, etc. So it is time that such legal frameworks as these are viewed through the human rights lenses, and that lens has to be outside the purview of the heterosexual worldview. So we need to now today look at all these issues through the human rights lenses and through a non-heterosexual perspective of the world. These personal laws need to change, because a woman need not be arrested or live in a war situation, war-torn area, to be tortured. A woman can be tortured every day of her life in various ways, whether at home, whether in the streets. A woman can be tortured. A third gender person can be tortured in various ways, from discrimination by the family, by throwing the person out. We have so many examples of that. And many of the third genders, because they couldn't be accommodated within the heterosexual family situation, they were thrown out and they had to go into begging, etc. So these are all violations of human rights. And I think that is where our legal system needs to rethink and try to amend those laws, which will at least be more comprehensive and will be more inclusive of the rights of all. It was the process of women's movements which actually brought up these issues about women's rights, which leads up to the World Conference on Human Rights in 1993 in Vienna, which I had talked about in the very beginning, and which proclaimed that it was no longer enough to merely extend the existing mechanism of human rights to women, but to have, the activists argued that women's rights must be understood as human rights. That whatever definition the UN had given to human rights, that definition must include the understanding of women's rights. If there are gender-based abuses, that is, abuses meted out to women merely because they were female, and we can today add abuses which have been meted out to people merely because they were outside the heterosexual system, then these abuses must be seen as the abuse of human rights. So if a woman is not given her her right to a good health, access to a good health system, it would be a violation of the human rights of that person. So there should be a legal system in place where the woman can go, or the third genders can go and petition that their human rights have been violated because they have faced this abuse. So what was argued was that there must be a complete transformation of the concept of human rights, and the feminist perception of human rights stressed on the fact that the concept of violation of human rights must be shifted from the concept of state versus people to a society-centered one, where women's rights and the rights of the third gender were violated every day. So it could not be just state versus people, but it also has to be seen in terms of people versus people. So because, say, when you are there's violence against the third gender person, it may not be the state which is involved. It is actually the societal, the societal perceptions which are involved. So therefore, I would like to say that, like other movements for women's rights, the women's human rights movement has also evolved from women organizing on local, regional, national, and international levels around issues that affect their daily lives. And that's how the entire movement has begun. The struggle has been to place women's issues on the mainstream agenda. That has been the main struggle. So such struggles which aim at including women in all social issues obviously transform agendas and raises an all-important question whether the current hierarchy of rights, with civil and political rights at the top of the ladder, is actually a justifiable hierarchy. That you have civil political rights and then you have other rights. Is that a very justifiable hierarchy? What happens if you have at the top of that hierarchy things like violation of the individual rights, the rights of the individual by the society? If that could be a change in the hierarchy of rights. There has been important women's rights lawyers who have actually argued on these lines. For instance, there is this very important human rights lawyer, Rhonda Coquelin. She argues that in the women's movement, there is a strong potential to demonstrate that human rights are indivisible from other political, economic, social, and cultural rights. So she, as a feminist and as a lawyer, she's saying that even within, we can transform the legal system also by showing that we can demonstrate that human rights cannot be separated, divorced from other political, economic, and social and cultural rights. So this, that is, the right to employment, the right to develop skills. This has been one of the major problems for women's rights, that women are not allowed to develop this kind of skills which can allow them to exist with dignity. Similarly, with the third gender, they don't get access to the facilities which allow them to develop their skills. So this claim of indivisibility has also brought a major challenge to human rights laws, which has traditionally focused on the promotion of rights in the public sphere, the political sphere. So promoting the concept of women's human rights automatically involves efforts in areas considered to be in the private arena, such as insisting on educating women or training them to acquire job skills, or the right to have control over their bodies, that women should be the ones who should decide whether they want to bear children or not, how many they want to have. It cannot be a large family decision that this is what you have to do. So they should have control over their bodies. Demanding for accountability of the government in these areas clearly transforms the entire concept of human rights laws, because this is where I think the laws needs to be re-looked into, and women's activists, women's movement for human rights has been demanding this, that the government should be accountable to this. And making the government accountable means that the government should take responsibility for seeing that the rights of women are not violated in these areas also, of not allowing them to develop their skills, etc. So women's rights activists have actually also shown how conventional international instruments of human rights may in fact legitimize discrimination against women. For instance, with the rise of women's voice for recognition, there was an attempt to try and use what we call a gender neutral language. And this was as a way to show that the international policy makers were insisting on absolute equality between men and women. So they said that we will use a gender neutral language, we will not use he, she, etc. And just to show that there was equality between men and women. But such a position fails to take into account the reality of women's history, which has been a history which shows that it is impossible to bring about genuine equality by merely talking about equality. And that's what largely actually has been done. We have been talking more about equality, but we haven't taken the practical steps to bring in the genuine equality. Such gender neutral positions fail to address the fact that the reality under which all women exist is the subjugation under patriarchy. So we come to the more core issue, that of patriarchy, and this subjugation often works in a very clearly, sometimes in a very clearly visible manner, but very often patriarchy works in a very, very invisible manner that, which cannot be recognized even by the women themselves. So, that is where we need to be very, very conscious about how patriarchy works. So granting equality under the law need not necessarily mean that women will really enjoy that equality. Because so far as you are within that patriarchal, larger patriarchal system, it's not necessary that women will enjoy that equality. When you say that equal pay for equal work is a law, and that women will also get equal pay, but can it really happen? Does it happen? These are the questions that one has to look into, because in most cultures, female workers are ghettoized in what is called female jobs. So if they are in a factory, they will be put into female jobs like weaving, doing things which are considered to be female. And most women work outside the home and also within the home. And a large part of the women's work is what we call in the informal sector. So equal pay for equal work, these concepts like equal pay for equal work becomes absolutely meaningless, because a large part of the work of women is in the informal sector, where no payment in structure exists. You say, there's no payment. So equality, therefore, will not come about. Or, for instance, women have been granted, you say, equal rights for expression, freedom of expression. But does that freedom have any meaning for women who have been denied the right to education, for women who cannot read or write, or who have been silenced by various other ways? So I think there are enough examples to give where women's voices have been silenced, even to the extent that in the name of their security, their mobile phones are nowadays taken away. So when you silence the voice, the society silences the voice, then what is the meaning of talking about freedom of expression? So these are issues, I think, which the human rights laws must take into consideration while talking about equal rights for women or for the third gender as well. For instance, if we look into the question of inheritance of property rights. Now, in the context of India, the courts have given, the Supreme Court has also enacted the laws that women have equal right to the inheritance of their paternal property. But does that really happen? Because the society always looks askance at a woman who is trying to fight for her rights of her paternal property. The usual thing that is said is, oh, look at this woman. She is trying to get a share of her brother's, trying to take away her brother's rights. It's very seldom is it said that this brother is taking away the rights of the sister. You see, so the society, our laws may be quite progressive in some ways, but our society is very, very regressive. And therefore, in such a situation, it is difficult to talk about equality between men and women to the same extent. So, and the situation for the third genders is even worse here because they practically have no recourse to the legal system and are discriminated against even in the case of getting employment. And there has been a very important, and it was quite some time back, where 2 women constables lost their job because they decided to cohabit. They decided to live together. And then, of course, it came to the courts. But at that time, the 377 had not been read down. So obviously, these 2 women were thrown out. They were police constables. They were thrown out of their job. Of course, the reason that was given was that they were absent from duty without any information. But that was actually not the case. And Indira Jaising has written a very good article on that, showing how it was actually a violation of all rights of women. That you lose your employment if you do not fall in within the patriarchal heterosexual confines. If you are outside that, then you don't even have the right to work. So therefore, there has to be both the establishment of structure for the prevention of discrimination and also legal punishment for discrimination. If there is discrimination, there has to be a proper legal punishment, and it should not be a kind of punishment where the perpetrator will just lie in jail for or get out on bail and then no action taken, and after 20 years they'll say that no, this was this person was not is acquitted. So it has to be a system of a kind of a legal system which can give immediate justice so that discrimination cannot take place. The CEDAW, which I talked about, the Convention on Elimination of All Forms of Discrimination Against Women, was a major international step towards laying out not only provisions forbidding discrimination, but also active provisions for remedying historical inequalities. But it is very important to know that many of the countries that have ratified CEDAW still have discriminatory laws. They say they have ratified, they have accepted CEDAW, but they still have discriminatory laws governing marriage, land, property, and inheritance. And even in 1994, in the International Conference on Population and Development in Cairo, it took place, it articulated and affirmed the relationship between advancement and fulfillment of rights and gender equality and equity. So we have had international conferences after international conferences. But the question is, we have to ask, what has been the final outcome of it? Many of the countries which have accepted all those outcomes of those conferences, they do not apply them, or they do not have, if it is necessary to change their legal structures, they have not done that to give actually protect the rights of women and the rights of those with different sexual preferences, the third gender. So in spite of all the international agreements, the denial of women's basic human rights is persistent and widespread. For instance, over 500,000 women in the world continue to die each year from pregnancy and childbirth related causes. Now that's, I think, the tragedy of human civilization, that a woman has to die because of related to childbirth. And then women have been, have died of cancer, many more women than men, because of the fact that they do not have proper access to health facilities. HIV/AIDS cases have been more rampant amongst women because of stigma, because of their not getting proper health facilities. So while progress has been made in some areas, many of the challenges and obstacles identified in 1995 still remain, they're still there. And human rights for women, as for all individuals, are protected within the international tenets of international law and international conferences. But declaration may be an important first step, but does not automatically change practice. That we must understand. There are a whole lot of declaration. Yes, it is an important first step that you are raising an awareness, but it is definitely not, it does not change practices. I'll just, I'm coming towards the close of what I want to say, and I'll just give you one, little quote from leading lawyer Catherine McKinnon, who is a professor of law in the University of Michigan. And this is what she has said. She has written, human rights principles are based on experience, but the experiences have not been those of women. What most often happens to women escapes the human rights net. Even the human rights net does not even catch what happens to women. Whether in peacetime or in war, at home or abroad, in private or in public, by our side or by the other side, man's inhumanity to woman is ignored. So that is what McKinnon has said about women. Now, I will just interpolate a few of the words and let you see, then you can see what is happening to the third gender. Human rights principles, I'm reading the same thing, but I'm putting in a few different words, are based on experience, but the experiences have not been those of the third gender or the LGBT plus community. But the experience, what most often happens to the third gender escapes the human rights net. Whether in peacetime or in war, at home or abroad, in private or in public, by our side or by the other side, man's inhumanity to the third gender is ignored. So what has been said about women's rights can very well be said about the rights of the third gender. So I will, close by saying this, that what do we need to do in such a situation? In the existing kind of gender relations in a society, what we need to do is you cannot separate women's human rights from the concept of rights in general and the struggle of the women for equal rights in the society in all respects. And the most important thing in that, I feel, is, we have to develop new concepts to see that, to get the acceptance of these new concepts and to look at human rights as through the feminist philosophy, lenses, and to have a feminist concept of human rights. But to get the acceptance of this, the most important requirement is that social values and attitudes must undergo change, and that requires a critiquing and questioning of patriarchal values and attitudes in all aspects of social thought and social relationships. The necessity, therefore, is sensitization and education so that the first step towards the building of a gender-just society can be taken, where a person will be recognized not because of sex, but because of the merits and qualities that the person has. This sensitization is needed for all, so that the lawmakers and our judicial systems also become gender sensitive. That's a very important thing, that our systems have to become gender sensitive. Many of our laws need to be amended in favor of women and the third gender, but only a sensitive legal system can make such amendments. Just, okay, this has happened, this is the article which is no longer there, so let's amend, and do it on a very superficial and insensitive way. The women and the third gender will remain where they are so far as human rights is concerned. So only thing we have to do is to move towards a gender just society, and it is only a gender just society which can have gender just perceptions of rights and human rights, and which can give a dignity to every individual, irrespective of their sex, whether they are heterosexual, whether they are homosexuals, whether they are transgenders, whatever, or whether they are women. They should all have their own dignity as individuals in the society. And only in that kind of a system of laws, legal system, judicial system, that the human rights of women and others who are discriminated against because of their sexual preferences or sexual mores will get justice, and their human rights will be protected. So thank you. I have said things which are very close to my heart, and I always feel that this is the lines on which we need to always move ahead to make a gender just society. And I hope we will be able to move towards that. Thank you very much, and thank you for your patience.
Thank you, ma'am, for your thought-provoking lecture. You have very rightly observed that the gender-based violations are because of the fact that we have the gender division of labor, and we don't have the gender-sensitive lens to see the rights of the third genders or women. So now I request our respected participants, if they have any questions, they can ask. Dear participants, if you have any questions, you can ask, ma'am. Ma'am, I think they don't have any doubt, but ma'am, I just want to know that since you have talked about the categorization of human rights, like we have the third category, like three generations of human rights, first generation, third generation, second generation, and third generation. But can we categorize the rights of the transgenders or the LGBT community as the fourth generation of human rights, like the right to internet, right to access to information?
Pallavi?
Yes.
Sorry for interruption. A few questions are there in the chat box. Please, if possible, please go through this so that ma'am can interact.
Yeah, I have a question in the chat box.
Okay, okay.
Yeah. So I request Dr. Pallavi Hazarika to read out the questions which are there in the chat box so that ma'am can interact with our learned participants. And few very excellent comments are also there in the chat box. Please read out this, so that will be encouraging for us.
Okay, sir, there is one question from Redif Khanifer. That he's saying that I'm just curious about your thoughts on the role of feminine masculinity in the gender bias construction of rights, particularly in terms of landed property rights and the LGBT community. So, Redip, can you please explain your question or your comment?
It's my question. I just want to know from ma'am.
Yeah.
What is ma'am's? Yeah. May I repeat the question?
Yes, you please repeat your question because you have just commented. So I'm not
Yeah,
getting
I'm just I'm repeating. Yeah, I'm just curious about ma'am's thought on the role of feminine masculinity in the gender bias construction of rights, particularly in terms of landed property rights and the LGBT plus community. What is the role of feminine masculinity in the construction of gender biased, understanding of rights, especially in the landed property questions? I'm just want ma'am's ideas.
Ma'am, please switch on your speaker, ma'am.
Yeah. Can you just elaborate for the other participants your idea of feminine masculinity? Because that is a very, very debated idea, the feminine masculinity idea. And because that could sometimes very often go against the interest of the feminist movement and the women's struggles. So how do you view this idea of feminine masculinity? Yeah. Yes, Ridip?
Redip, ma'am is asking
Yeah, I
you
think
to elaborate your conception.
okay. I just thought that because it's interesting to know how others also look into these issues, because the role of I personally think that this whole idea of feminine masculinity is an idea which is being developed in a way to try and obstruct some of the, or bring in patriarchal values or views in a very, very clever manner. So when we are talking about the rights of all the marginalized, I think the question, I don't see how if the question of feminine masculinity comes in, then that should not be, something that, that should be something that is debated. Because if we are talking about the rights of women, so far as landed property is concerned, then, or we are talking about, the rights of the LGBT community, then there should be, that's where should have a set of laws or the proper, land laws, which would regulate the inheritance laws. Because as of now, the inheritance laws, which are a part of the personal laws, which we had talked about, those don't give much space for the protection of the rights of anyone else except the heterosexuals. And here, if the feminist movement says that, or some of the feminist say those in the movement say that no, now this is a space for the women and we cannot have transgenders, etc., coming into it. I think that would not be a very, very correct position to take, or correct, very in terms of human rights, or in terms of protecting the rights of all, irrespective of their sexual preferences. I don't think it will, and most of those in the feminist movement have not really taken such a position. There is a small group, yes, they do have that idea that the transgender should not be allowed to come into the women's space or the female space. But then one has to understand the position of the gay, the lesbian, the bipolars, or the bisexuals, the transgenders. Do they call themselves males or females? So that one has to go beyond that thinking, of thinking in terms of this binary of male and female. And then I think the question of the idea of feminine masculinity can be looked at more realistically. Yes, Ridip, does that answer your question?
Madam, there is another question from Rupjyoti Das. That can I have the names of eminent feminists of the 20th century and why the women facing atrocities in detention camps under state and not other, as you have mentioned?
Yeah, I have seen this. To give you the names of eminent feminists of 20th century, there'll be quite a long list. So let me not go into that. There are some whom I have mentioned, and maybe in one of the slides they'll be there. So in the 20th century, there have been, beginning from Simo Bora to Betty Friedan. There's a whole list of them. See, so we can, we can have an entire list, both from India. In India also, there have been a number of feminist, fighters, feminist in the feminist movement. So we have a whole group of them. So I don't know why just the names are important, but yes, we do have feminists from over the world. But the question about women facing atrocities in detention comes under state and not others, as you have said. Obviously, because you see, those women who are do you mean detention camps or in jails, whichever? Yes, women who are in detention, they are supposed to be, they have been put there by the state. They have not been put there by societal group. So in detention, the state. And Buckley argued that other women's groups outside definitely have raised their voice about the condition of women who have been put in detention, in whether they are in jails, whether they are in correction homes or wherever. But there has been groups which have been working to try and understand the condition under which women work. Even in Assam, we have groups which are working to try and understand the condition of women prisoners in the correction reform homes, correction homes, detention camps, and they have tried to intervene with the state to see that there should be proper, the human rights of these people, of these women must be protected. They cannot be just separated from their families, separated from their children, against all facets of human rights. So definitely, therefore, that becomes a responsibility of the state, and the state obviously is a very state, let me tell you that. And the state is therefore not really interested, and that is why women have had to organize. State understand that, at the patriarchal state, understand that women's experiences are also experiences which need to be taken into consideration, whether you are talking about human rights, whether you are talking about development, whether you are talking about protection of, the rights of on land, whatever. So that is why we have the movements. If the state was a very, very gender sensitive state, then obviously, many of these things would not have been necessary. Was that your question, Rupjyoti?
Thank you, ma'am. Very well said, ma'am. Thank you so much. Yes, I have got my answer. It's very clear. Very lucid presentation, ma'am. Thank you so much.
Anything else? Let me see, I'm looking into the chat box to see if there are any more questions. I can't see any more. Okay. So, someone was asking this question, Jonali Das. Perhaps she didn't have time to write the whole thing. Property rights is there, but most of the time women leave it. The question is not complete. If Jonali is available, you can complete your question. I think that's a very interesting question you are raising. It seems that we have lost connection with Jonali, or is she not there?
Ma'am, Jonali Das is here. Dr. Jonali Das will interact.
Okay. She wrote a part of a question and didn't complete it. She can complete the question.
May I request Dr. Jonali Das to interact with ma'am directly?
Hello,
Yes.
ma'am. I have one question. Property right is there, but most of the time women leave it due to their emotion. Do we think that it happens because of our bringing or our emotional bonding?
Yeah, I think you have just hit the nail on the head. You see, and that's the point I also made, that property rights are given to women, but why do women have to leave it? What controls their emotions? Why do they leave it? See, because of the whole process of socialization of women from the time that they're small, there's a small girl. From that time, they have been brought up in this idea that the world is patriarchal, that it is the brother who is important, it is the father who is important. So if property has to be inherited, it has to be inherited by the brother, by the men. So that is the kind of socialization which goes on, and the society is also extremely, I would say cruel in a way, that if a woman decides to fight for her property rights, there will be very few, even amongst, even amongst the women who will support her. They will say that, look at this woman, she has got her education, she is now married off, or if she's not married off, she's whatever, she is free. Now she wants a share of her father's property. So the society is also not, with the women. And that's why I said somewhere in the lecture that many of our laws are quite progressive, but our society is very regressive. It does not understand, it does not believe in the equality or in justice to women, does not believe in gender justice. And that's why I ended by saying that we need to actually have a very clear critique of patriarchy, because patriarchy works in various invisible ways also. And when you say a woman gives it up because of her emotions, that is an invisible working of patriarchy. Her emotions have been actually molded by the society, that her emotions have to be in favor of men and not in favor of herself. So the question that you raise is very correct, that property rights have been given, but women cannot exercise them or cannot benefit from them, because the society by and large does not allow them to benefit from it. So until and unless we can loosen, or unless we can weaken and understand, recognize the patriarchal values, patriarchal norms, the patriarchal ties which restrict the thinking, the working, the life of the woman, it will be very difficult to move towards a gender just society. Thank you, Jonali, for bringing this up, because I had already talked about it. Yeah.
Thank you, ma'am, for your valuable talk. And we are getting much more information about the women rights as a human rights. Thank you. Thank you, ma'am.
So much. Thank you so much. It was been nice sharing my ideas with you.
If there is no question, can we conclude, ma'am, for today?
Yes, please. If no other questions and nothing more to say, or if anyone wants to give a comment, also their own views, I'll be very happy to hear it, actually.
Thank you, ma'am. Here is Dipen. Thank you very much for ma'am coming to our program, and you have enlightened us with your one presentation, giving us your valuable time. On behalf of our this entire organizing committee, I would like to say thank you so much, ma'am.
Thank you, Dipen, and thank you to all the participants for being patient. And also, I can see that you have been thinking. And that is the reason I don't make a PowerPoint presentation. Because if I had made a PowerPoint presentation, you'd have been busy taking down what is there on the slides, and then you wouldn't have thought. But since you are listening, whatever way you have put in your thought into it. So thank you so much for your patience and listening to it. Thank you.
Yes, ma'am. So many comments are there in the chat box also.